Good afternoon, everyone. Welcome to the Banking on the Futures Conference. First, thank you for being here today. I'd like to start by saying thank you to our co-host, Space Autastic, Kate, thank you, out of Janesville. The professionals exhibiting today, sponsors, and our wonderful volunteers that took the time away from their families on a Sunday to support our community. Whether you're a parent, caregiver, professional, or community sponsor, your presence here matters. We created this conference because we know firsthand what keeps families of our loved ones with disabilities up at night. The what ifs. What happens if something happens to me? Who will care for my child? How do I make sure they're financially secure, protected, and supported long after we're gone? These are not easy conversations, and too often families are left trying to navigate this alone. At Morgan's Care and Connection, our mission is to help families create peace of mind through education, trusted resources, and financial support for long-term planning. This conference was never about generating income. It was about creating access. Access to answers, access to professionals, and access to conversations that families deserve to have without fear of overwhelm. Today is about taking the first step for many of you, asking the questions and knowing you are not alone in this journey. We are honored to walk alongside you. And we hope that you leave feeling more confident, more supported, and most importantly, more hopeful about the future. Thank you for being here. So I want to thank our session sponsor, Gunderson Funeral Home. I want to introduce Dera. Dera Johnsen-Tracy is a shareholder and co-founder of Horn & Johnson in Madison, Wisconsin. She is top rated by super lawyers, has been a featured presenter at various conferences, both nationally and throughout Wisconsin, and is co-author of the book, Wills, Trusts, and Probate, an insider's guide to estate planning in Wisconsin. She is also my estate planning attorney and personal friend. So without further ado, I'm going to let Dera get started with her presentation.
All right, good afternoon, everyone. I am Dera Johnsen-Tracy, as Janice mentioned. I'm an estate planning attorney here in Madison. I actually started my legal career in 1994 when I went to work for a general practitioner down in southern Texas, which is where I'm from, as a paralegal. Realized I really enjoyed the law, but not so much the litigation part. You have to have a special personality for that. It's not me. And then in 1998, I moved to Madison, and I went to work still as a paralegal for a law firm that specialized in estate planning. And that is where I found my passion for death and taxes and everything that goes along with that. There is a Volkswagen in the parking lot. The license plate says death and taxes. That is my car. I spent 10 years working as a paralegal, going to school at night, as a single mom. But the beauty of that is by the time I graduated from law school in 2008, I knew exactly what I wanted to do, and that's estate planning. So I'm very fortunate that I can focus on that at this time, because I can keep my clients out of court. If I can do that, I don't have to go to court. It's a beautiful thing. So this is my family. So my husband, Brandon, he actually owns Superhero Martial Arts, which is a martial arts academy where he works exclusively with children and young adults with various disabilities. So we've been very active in particularly the Verona community and surrounding communities for a number of years. I have a 31-year-old daughter. It's hard to say. She's 31. And she's adulting out in Denver. And then we have our Layla, 13 years old. So I have a 31-year-old and a 13-year-old. I like them one at a time, 18 years apart. It works for me. She's on the dance team. She's on the Junior Wildcats dance team here in Verona. And the reason that I like to start most presentations by introducing my family is because when we're talking about estate planning, there's no such thing as a one-size-fits-all approach, right? Every family looks different. Some people have children with various disabilities. Sometimes you just have minor kids. Sometimes you have kids are in the in-between zone, pseudo-adults, right? Technically they're adults, but the brain isn't even fully developed until you're like 27 or 28, something like that. And maybe you don't want them to get big chunks of money. Sometimes we name charities. Sometimes we have elderly parents we want to take care of. So every family is different. Again, not a one-size-fits-all approach by any means. So I'm very briefly going to talk about guardianship. I'm not going to get into the details of that, but we do have a presentation coming up through Morgan's Caring Connection for those of you who would like to talk about guardianship in greater detail. But I do want to briefly put out there what happens when my child turns 18. All sorts of things happen, right? They're going to qualify most likely for certain benefits. Do they need a guardian? Do they not need a guardian? And all of that is where you're here with these resources in this room. People can help make that determination. There are two types of guardians in Wisconsin. There's the guardian of the person, and that's the person who decides where they're going to live, living arrangements, education, healthcare. And then there's also a guardian of the estate. Two separate roles here. And the guardian of the estate is the person who's going to help set up the new checking account, help get qualified for benefits, help take care of tax returns, maybe leases, things like that. And so again, we just need to know when your child turns 18, ideally before, right? We can get this started about 6 months before your child turns 18. Things to consider, but again, I won't get into that in more detail today. So according to, and this has been for years actually, recent surveys say the same thing, Rocket Lawyer, over half of American adults have no estate plan in place. They have nothing, and I get it. Who wants to think about this stuff? I think that one of the reasons people don't have a plan is because there's a myth that estate plan, trusts, you have to be wealthy for something like that. But that is completely untrue, right? Do you guys remember Terry Schiavo? It was a long time ago, a young woman down south. She became incapacitated unexpectedly. And the issue was that her husband said, there's no way my wife would want to be kept alive artificially like this. And her parents said, we want to keep our daughter alive as long as possible. That resulted in a 7-year court battle, right? At the end of the 7 years, the judge let Terry go. But the reality is we wouldn't even know her name today if she had some basic estate planning documents in place. So estate planning is important for everyone. And the goals of estate planning are going to look different. Like I said, every family's different. We plan for the present, and that's all we can do. Sometimes I have clients come and they say, well, how do I know, in the future what's going to happen 20 years down the line? I want my parents as guardian now, but maybe when my children are teenagers, that's no longer going to be an appropriate situation. All we can do is plan based on today's circumstances and review, right? For my clients, I like to see my clients every 3 to 5 years, at least, to check in, to make sure everyone's still in the right seat on the bus and to see how everybody's doing. But all we can do is plan for the present. We want to plan for incapacity, which we're going to talk about, and we also want to plan, of course, for death. And avoid probate and save taxes, maybe. It depends on the circumstances. So with regard to the estate tax situation, as of today, and I can't tell you what it's going to look like next week, next month, next year, who knows? Everything is kind of crazy right now. But unless you're worth about $15 million, estate taxes are not a concern right now. So for 99.9% of us, it's not something that we need to be concerned about. And avoid probate. Maybe, and the reason I say maybe is because I would much rather see a life insurance policy go through an organized probate court proceeding to get to a special needs trust that you set up for your child, right, than to not have a will in place, and that can be a mess on its own, which we're going to talk about. So maybe avoid probate. So when we talk about your estate for estate planning purposes, Most of us are worth more dead than alive. That's totally normal. And so the value that I'm looking at is the amount that would be available to distribute to your loved ones when you're gone. And that's going to look different from what your net worth is according to your financial advisor, right? And that's because we're considering everything. Any real estate that you own, retirement plans, whether or not you're taking distributions, doesn't matter. It's still an asset of your estate, your cash, your stuff, your jewelry, and the death value of your life insurance. That's a huge consideration, and we all need to think, okay, I have $200,000 life insurance policy. Do we need to protect that? Do I have a young adult child who really shouldn't have free access to $200,000 in cash? So definitely consider that. So there are some essential estate planning documents that everyone needs to have in place. And this is whether you're, and many have heard this before, that whether you're 20 or 90, unless you can guarantee me that you're never going to die or become incapacitated, yes, everybody needs these essential estate planning documents. So a property power of attorney is also known as a durable power of attorney, a financial power of attorney. They all mean the same thing. But this is where you give someone the ability to take care of all financial matters during any period of mental incapacity for yourself, right? So for example, let's say you're married and you own your home and both names are on the deed to that house. If you don't have a property power of attorney, financial power of attorney in place, if your spouse becomes incapacitated, you can't even sign a deed to sell your own house without going to court. So even for married people, you must have a comprehensive financial power of attorney. And then on the healthcare side, there are several different pieces to the healthcare puzzle. Everybody, again, even married people need to have a comprehensive healthcare power of attorney in place for each other. Most people like to have some living will language, and that's where you indicate whether or not you'd want to be kept alive artificially under certain circumstances. And HIPAA is very important. If you have children with special needs, you probably have run into this many, many times, right? Deals with medical privacy. So without an active HIPAA authorization on file, sometimes even your spouse can't call the hospital and see if you're there because that's protected medical information. Now, if you read the fine print, because many go, I have a HIPAA, it's on file with my doctor. Read the fine print. Number one, it's only valid for that network. So if you are out of town, it might not do you any good. In fact, it probably won't. And it expires every year. Everyone I've seen that you signed at the doctor's office. So, and men are notorious. You guys don't go to the doctor for years, right? And so if you don't go at just the right time every year, there's a period where maybe no one has access to that information. And if you do have adult children who can sign legal documents, this is important that they also have a HIPAA authorization on file so that you can get their information and that they have a healthcare power of attorney, right? Personal property memorandum, many people, not everyone, but many people have specific items they want distributed to specific people. Jewelry or collections or instruments, whatever it is. Wisconsin law makes it very easy to make those types of distributions. Wisconsin law says if your will or trust specifically incorporates what we call a personal property memorandum, then you can just make that list on your own, sign it, date it, keep it with the other documents, and it's completely valid. Right? And then you don't have to see your attorney if you change your mind about a piece of jewelry or something. You can just update your list. But the will or trust must have the proper language to accomplish that. And then funeral planning. It's another area nobody wants to think about, but we have Heather back there who is a fantastic funeral planner. I've worked with her personally actually for over a decade. I know you don't want to think about it, but number one, at least write it down. It's the first opportunity for families to argue about something, right? The first opportunity, and emotions run high, it's stressful, sometimes there are different religious beliefs involved, and so you want to write down what you want, or better yet, pre-plan with a funeral home, and you also want a legal document called an authorization for final disposition, and that's a funeral authorization where you designate the one who you trust to follow through with those wishes, right? So if you want to have a celebration of life and a basic cremation, but you know your mom would give you a $20,000 church funeral, we can't name her because she's not the right person for that job, right? And then last but not least, a will or a living trust, and we're going to talk about the difference in just a moment between those two. But you can see why each piece to the estate planning puzzle is very important. It's not about just getting a simple will in place. There's so much more than that. So before we talk about wills versus trusts, I want to briefly touch on different types of special needs trusts, right? Because I'm sure, again, as you know, if you have a child who's receiving SSI or other benefits, they're usually limited to the number of assets, the amount of assets that they can hold in their own names. So on SSI, you can't have more than $2,000, right? And so we have to make sure anything your child inherits or your loved one inherits or that accidentally comes to them is protected so they don't get disqualified from the benefits. So a first-party special needs trust is a trust that is established by the individual with the individual's assets, or by someone else but with the disabled individual's assets. So let's say your mom accidentally named your child with special needs as the beneficiary directly of a $10,000 life insurance policy, right? That's a problem. They can't have $10,000. And so that would be a first-party special needs trust. We would put that life insurance, those proceeds, into a special needs trust with your child's assets because they were named directly, right? Now, we can keep them qualified for benefits, but if it's first party, there's always going to be a payback provision, meaning whatever benefits the government had been providing, anything that's left upon that person's death is going to go back to the state as repayment, most likely. And that's compared to a third-party special needs trust. So let's say instead, Grandma set up a special needs trust in her will for your child with special needs, right? So now on her death, and she named it, we have to make sure the beneficiary designation matches that, right? She has a special needs trust in her will, but she named the child directly. That's not going to work. Beneficiary designations must fit with the estate plan. But let's say she did it properly, had a special needs trust in the will, the life insurance went to the special needs trust. There's no payback provision. Your child is fully protected for all of their benefits, but if anything happens to your child, whatever's left is directed by the creator of that third-party special needs trust. So there's a big difference there. And then we have pooled special needs trusts. And this is where another option, as opposed to paying for a private trust, is, for example, WISPACT. It's a pooled community trust program for individuals with special needs. It's very affordable. In fact, in most situations, if we need to set up a trust, a special needs trust, it might not cost anything because WISPACT pays the attorney's fees provided the initial funding is under a certain dollar amount. Now, the person with this type of a trust, who's the advisor on the account, they don't have management control, so they can't decide how to invest the assets or anything like that. But it's really nice, it's really cost efficient, they take care of the tax returns for the trust, and they keep your child qualified. And you can set this up as either a first party or a third party special needs trust. If there are higher value assets, though, you might want to consider a private trust so that you can work with your advisor to invest the assets with a more flexible approach, right, as opposed to what WISPACT or another program similar might offer. So, okay, let's talk about wills, and let's talk about what they do and what they don't do. And so a will is the only place in Wisconsin where you can legally name a guardian, right? So the will does name the guardian. It designates the personal representative. That's the executor of the estate, the one who's in charge after you're gone. And your will can also establish how the assets are going to be distributed when you're gone. And within a will, you can create what we call a testamentary trust for your child with special needs or a minor child or somebody else. A testamentary trust springs into existence after you're gone through the will, right? But what it doesn't do is it doesn't do anything if you become incapacitated, which we talked about, all the powers of attorney that are necessary in addition to the will, and it doesn't avoid death probate. So if you have a will, and if you're depending on that will to fund a special needs trust, to transfer assets when you're gone, the only way to get to that trust in your will is by taking the assets through the death probate process. Now, it's not the end of the world. It's just kind of a pain for whoever has to deal with it. If anybody in here has dealt with a probate for parents or grandparents, you know what I'm talking about. And it's simply because it's a court proceeding. Whenever we're in court, nothing happens quickly, cheaply, or privately. It's simply the nature of the beast, right? So on average, a probate proceeding in Wisconsin takes about a year. It's just because there's a lot of paperwork we have to get through. We have to file with the court. We have to publish notices in the newspapers giving your creditors 3 months to come file a claim against the estate. The executor won't have immediate access to the life insurance until we get the order in court, and then for the pleasure of using the probate process, the courts are going to charge $2 per thousand for the inventory filing fee, and that doesn't include attorney's fees, it doesn't include publication expenses or anything like that. And then in the end, it's all public. So anybody could, we have open records laws, it's probate. Anybody could go online, see how much your children inherited, names, addresses, it's all out there. Anybody could even go down to the courthouse and get a full copy of your will to see at what ages certain beneficiaries might be receiving chunks of money. So for those reasons, many people choose to avoid probate. So how do we avoid that process? Well, let's talk about assets and how they're titled. So if you have an asset, your home, for example, that's an easy example, and it's titled solely in your name, if you die, then your home is going to have to go through a probate proceeding. If your estate is named as the beneficiary of a life insurance policy or retirement, that also is going to go through probate. So to avoid probate, one option is joint tenancy. So again, I'll use real estate as an example. So you and your spouse, you own your home together, both names on the deed. If one of you dies, the survivor is just going to inherit that home, no probate, right? You have two names on the deed. But I do want to mention, let's say you have property with siblings, and so it just has three names on a deed, right? You inherited part of a farm up in northern Wisconsin from your parents. It's you and two siblings on a deed. If one of you dies, then that sibling's interest in the property will have to go through probate, right? That's what we call tenants in common. It's all about the wording on the deed or the lack of wording on the deed. So very important, something to consider. You can name somebody as a POD, payable on death beneficiary of a bank account, for example. And what happens is when you die, that person just needs to bring your death certificate to the bank, and the bank will release the funds, no probate, right? And transfer on death is similar. It's more for investment accounts, stocks and bonds. You can name a TOD beneficiary. And again, when you're gone, that person simply receives that account outside of probate. And then, of course, typical beneficiary designations we think about for life insurance policies and retirement plans, things like that. So it sounds great. Let's just name direct beneficiaries on all of our assets. Be careful. Again, if you have a loved one with special needs, you can't name that person as a direct beneficiary, whether it's POD, beneficiary on life insurance, whatever it is, you can't do it because you're going to disqualify them from the benefits, possibly. Also, if you have, as I mentioned, if you have a younger child, but an adult, we don't want 18-year-olds getting a bunch of cash. I'll put it that way, right? That's never in anyone's best interest. So maybe you have some grown-up kids, but they need some protection. Or maybe you have a beneficiary who has health issues themselves. Maybe they're not disabled, but some sort of a chronic condition, and they might wind up bankrupt due to medical bills someday. Right? Maybe they want a trust instead so that they can have some creditor protection. And what about future marriages? So I'm not talking about marriages of your children or even your future marriage. I'm talking about the marriage of your spouse if you die first. So it's something to consider. And this is one main issue with what we call I love you wills. And these are the most common types of wills. You're a married couple, you're not even a blended family, right? And you have a will that says, when I die, everything goes to my spouse, and when we're both gone, it goes to our kids. Sounds simple, right? Okay, one of you dies, the survivor gets lonely, gets remarried. Well, what happens over the years is with that new spouse, he or she becomes the new beneficiary of life insurance, of retirement, right? They become the joint owner of the home. And if your spouse dies, that new spouse can completely disinherit your kids. Happens all the time, and there's nothing that I can do for a disinherited stepchild. So, going back to how do we avoid death probate without causing all of these issues? So you can name direct beneficiaries, but again, if you have an individual with special needs, you can't do that. Another option is to create a fully funded revocable living trust. So think of a trust. Some people get nervous. I don't want to give my assets to someone else. I don't want of course not. This is a different type of a trust. Think of it as a box. So we build this box called your trust, and we put everything in the box, right? But you, the creators of the trust, you are the grantors, you're also the trustees of your own trust, and you're also the beneficiaries of your own trust during your lifetime. So by creating a revocable living trust, fully funded, you're not giving up any control over your own assets, right? So here's a picture of just a hypothetical revocable living trust. So we have David and Susan Smith, live here in Verona. They created a living trust. So again, we built the trust, everything went into the trust. So we transferred their home and any other real estate interests into the name of this trust. And with regard to real estate, I also want to mention, if you own real estate in more than one state, if you don't have a trust, there's going to be a separate probate proceeding in each state in which you own real estate. If you have a living trust, we put it all into the trust. We name the trust as the beneficiary of your life insurance policies, right? We assign personal property to the trust. Future vehicles might be purchased in the name of the trust. All bank accounts are assigned to the trust. Checks don't change, direct deposits, withdrawals, that doesn't change. I wouldn't do that to you. I'd have upset clients if I did. The only difference is that the bank statement shows that the account is owned by a trust instead of by you individually. So it's really just something that happens in the background. Any non-retirement, stocks, bonds, investments, those also go into the trust. Now, retirement is a little bit different, and when we have a trust, you have to be very careful with retirement for tax reasons, right? So an IRA, 401k, 403b, annuities, anything that's tax deferred, those accounts stay in your individual name. If you're married, we keep your spouse as the primary beneficiary for tax reasons in most situations. And then if you have a child with special needs, we definitely are going to name the trust as the contingent beneficiary, right? So we build the box, we put everything into the box, you're in charge, so David and Susan are in charge of everything. So now David dies. So now Susan is the surviving spouse. And so this credit shelter trust that I'm going to talk about, this is not for everyone. Some people, everything just flows through to the survivor's trust. Very simple. On the first death, the spouse is just the sole trustee. But for my husband and I example, we are a blended family. And so if I die, my life insurance is going to go into that green box, that credit shelter trust. Everything else is going to flow through to the yellow box, to the survivor's trust. So for our home, for our investments, our retirement, everything, he can do whatever he wants with that. And he's still the trustee of the credit shelter trust, but that is only available for him and my descendants. He can't name his new wife as the beneficiary of that trust, right? And I tell him, it's not that I don't trust him, but I don't trust his future wife if I die. And I think that's fair. And he married an estate planning attorney, so it is what it is. And so again, there's that protection there. So I know the death value of my life insurance is going to be used for its intended purpose. Again, not everybody needs this, but if you are a blended family, it's certainly something to consider. So now the second spouse dies, so Susan dies. Now, if Susan had a will, again, everything would have to go through that death probate that we talked about, right? But because there's a trust, they have 3 kids. Sarah she's the accountant, she's the responsible kid in the family. And then we have Tommy, who's in his early 20s, still living in the basement, playing video games, right? So for him, we have another solution. And then we have Cindy, who has some special needs. So Sarah is the trustee of her parents' trust after they're both gone. And so the difference here is that for Sarah, she has immediate access to the life insurance. All she needs is the trust document and the death certificate. She claims the life insurance right away. She can hire a realtor immediately to sell the house. She privately, quietly pulls it all together, pays the final debts and expenses, burial, funeral, medical, files the tax returns, and then funds these 3 separate private trusts. So for Sarah's share, she doesn't need protection, but it's still a trust. She's her own trustee. She can do whatever she wants with the assets in her trust. But whatever Sarah chooses to leave in that trust has a lifetime of both divorce and creditor protection for her. So if she had medical bills and she had to go bankrupt due to medical bills, she might lose everything else in bankruptcy court, but she won't lose the inheritance. If she gets divorced, even if there's no prenup, her inheritance is fully protected. It's called a beneficiary-directed trust. It's a nickname, and these have been tested through the court systems for decades. They work really well to provide that protection for your loved ones. And then Tommy, like I said, he's just young. We're waiting for the brain to fully develop. He'll get there. So until he's 30, right, he is going to have maybe a professional trustee, and he can choose maybe Lake Ridge Bank or any other professional trustee he likes to work with, like Life Navigators. But he needs some oversight. So there's someone there to help him make good life choices until he's 30. And we decided not to name his sister because it gets messy, right? If you have siblings who are in charge of the trust So we'll name a professional. And then for Cindy, she of course needs a special needs trust, right, to keep her qualified for all her benefits. Sarah is the trustee of Cindy's special needs trust. The assets are always available for whatever the government doesn't provide. So we keep her qualified for all the benefits, and we also make sure that it's nice and private and that she has what she needs to maintain her standard of living and to do extra things like going on a vacation, maybe going to camp, getting a new iPad, right? Whatever she likes to be, taking martial arts classes, whatever it is that Cindy likes to do, that money is available for her, but it won't disqualify her. If anything happened to Cindy, this is a third-party trust, so it goes back to her siblings. And so we don't have to worry about any payback provisions. And so I want to be clear, I'm not telling you that everybody needs a trust, but it is a really nice option, especially if you have loved ones with disabilities, because here, no one would have any idea how much David and Susan were worth or who got what, because it's completely private. So, the moral of my story today is don't be like Prince. I don't know if he didn't have anything. Prince had no will, he had no trust. His attorneys told him, I've looked into this for years, you have to get something in place. But he kept saying, no, if I do that, that means I'm gonna die. Well, so he was a major star, cultural influencer with all of these resources, and he didn't take care of it. So it all comes down to taking care of business. If you don't take care of it, you're leaving a mess to the family or to the courts. All right, at this time, I'd like to open it up to any questions that you might have.